Welcome to Sidebar in the Sunshine State with Adam Pollack.
Hey everybody, welcome to the first episode of Sidebar in the Sunshine State with Adam Pollack. I am your host, Mike Leon. Adam here is a board-certified criminal trial lawyer out in Orlando, and he's been defending clients all throughout the state of Florida. Decades of experience handling everything from misdemeanors to serious felonies. He believes there's no greater honor than protecting someone's freedom and their future. And in today's episode, we're going to be talking about Miranda rights. Adam's going to explain when they apply, when they don't, and what every Floridian out there should understand before you talk to law enforcement. Adam, it's good to see you. I live in the Sunshine State as well. So before we actually dive in here, tell us a little bit about your background. You've been, as I mentioned in the intro, a board-certified criminal trial lawyer for many years. What drew you to the criminal defense aspect?
Thanks for having me, Mike. I really appreciate this opportunity to get this important message out to citizens in the state of Florida and really to anybody that's watching this podcast. If you're in the United States, these Miranda warnings apply to everybody, whether you're in Florida or in Alaska or Hawaii. It doesn't matter. We are all part of the United States and we all abide by the same Constitution. But I really appreciate this opportunity because I've been a criminal defense lawyer for over 20 years, and I believe in the Constitution. I believe in the rights that the Constitution has given us. Words like due process, equal protection, presumption of innocence, those are just words. You need somebody to go into court to enforce those legal rights, and that's what lawyers like me do. We walk into court every single day, and we stand up to the government. We tell judges, we tell prosecutors, we tell police officers that they're wrong sometimes, and we give life and breath into the Constitution. And that's what the criminal defense lawyers do, and that's why I do this. I've always valued the idea that we're all created equal, no matter what color you are, no matter what race you are, whether you're a male or a female. It's important that everybody is treated equally and fairly in court. And that's what lawyers do. We stand up and we help make sure that our clients are being treated equally and fairly. And it's not just our clients that this right extends to. By standing up for those people, hopefully we're preventing future abuses from occurring to people who don't even realize that they could be the subject of a future abuse. So we try to put the fire out before it becomes a raging forest fire, so to speak. And so we hold the system accountable. At times we're even policing the police, and that's what I do, and that's what I enjoy doing. That's what my passion is. And I've taken that passion and I've gone a step further, and I've gone up to becoming an expert in this field of law. And well, what makes you an expert? Well, the years of training, going to trial, education, but also passing a very rigorous process set out by the Florida Supreme Court, and that's called board certification. And I joined an elite group of attorneys, less than 1% of the entire Florida bar, which is over 100,000 lawyers, have this certification of being a board certified criminal trial attorney. And so we use our skills every day to protect the legal rights of everybody.
Well, let's get into those legal rights because I mentioned in the intro about Miranda rights, and a lot of people know it from television, right? You got the right to remain silent. Anything you say can and will be used against you. So in real life, though, what do Miranda rights actually cover in the state of Florida?
So we've all heard about Miranda, or some form of Miranda. You're watching TV, and someone's arrested by a police officer, and they say you have a right to remain silent. That's like the buzzwords for Miranda. Um, but it doesn't just stop there. Miranda, it comes from our Constitution, the Bill of Rights, the Fifth Amendment, and the Sixth Amendment, which protect you from self-incrimination and having the right to a lawyer, the right to have counsel. And those are guaranteed rights in the United States Constitution. And that's what they are. But you have to know what that means. And so what it means is you don't have to answer questions when the police are asking you questions, especially if they could incriminate you. And what does you mean? It means, did you shoot this person? Well, yes, officer, I did. Well, you don't have to answer that question. Even if you are next to the dead body, so to speak. You don't have to answer anything. It's the police officer's job, the government's job to investigate the crime, and you cannot be used as a witness against yourself. Remember, anything you say can and will be used against you in court, and you have a right to an attorney. So if questioning starts and you don't want to answer the questions without a lawyer present, just say, I want a lawyer to be present. But it has to be a clear, unequivocal request. You can't just say, well, officer, do you think I should get a lawyer? Maybe it's a good idea I get a lawyer. No, you have to be very clear. I want my lawyer to be present. And you may not even have a lawyer yet, and you say, I want my lawyer to be present, and the questioning must stop right then and there. But Miranda it's one of those things that you have to understand when it applies and when it doesn't apply. Oftentimes, I'll get people who come to me and say, well, the officer never read me my rights. That means this must all go away. No, it doesn't mean that automatically, because there's two parts to Miranda. The first part is you have to be in custody, and the second part is you have to be interrogated. So you could be arrested and taken down to the jail, and the police never questioned you, and so Miranda warnings don't apply. Or, you've been arrested and you start telling the officer your side of the story, and the officer never even asked you a question. Miranda doesn't apply. Yes, you're in custody, but the officer wasn't asking you anything. You just decided to, try to talk your way out of the situation. Not a good idea. If you've been arrested, you need to remain silent, and let the lawyer take a look at what's going on. Let someone like myself, read everything to understand what's happening to you. Likewise, were you in custody? People say, they didn't read me my rights and they questioned me, but maybe you weren't in custody. Maybe you were, just walking down the street. The officer stopped you and said, hey, Mr. Smith, do you mind if I talk to you for a few moments? And you say, sure, no problem. Well, you're not in custody. In custody means, was your ability to terminate the encounter there? Could you just walk away? Could you ignore the police? And oftentimes it's a gray area. You don't know. So you've been pulled over for a traffic stop. The courts have held that that's typically not going to be an encounter that triggers a custody environment, because most people have been pulled over before and they walk away with a traffic ticket. But that same encounter where you've been pulled over and now the officer is telling you to get out of the car, and you try to walk away from the officer and the officer says, no, you're not going anywhere. Well, maybe that's turned into a custodial encounter. Now, well, you say, well, but no, the handcuffs weren't on me. Well, that doesn't always mean anything whether handcuffs are on you. That's the easy part. If handcuffs are on you, oh, sure, a reasonable person would expect that they're been arrested or they're in custody, and Miranda warnings would apply. But what's the situation where the police are talking to you and you try to terminate the encounter, and you can't walk away? Well, now your freedom has been infringed upon, and you've probably been placed in custody even though handcuffs have been placed on you. Or you go into a room and the door is locked behind you and you can't get out. You're in custody even though the handcuffs aren't on you. You're probably in custody because your freedom to terminate the encounter or disregard the police is not there.
So, Adam, let me go to a part that you just said there. So the police say, hey, Mike, good to see you. I can ask you a couple questions. Can what I say still be used against me, even though I haven't been formally charged? I'm not in custody. I haven't been Mirandized. Can that be used against me if I start answering there?
So if you are not in custody and you are voluntarily answering the police officer's questions, yes, your answers could be used against you. Um, Even if the police were conducting a criminal investigation, if you were not given the impression that you were not free to leave, so they just come up to you and say, hey, Mike, you mind if we start talking to you? And you say, no problem. I'll talk to you, officer. Uh, no need to give you Miranda warnings. Now, if you said, well, no, officer, I really don't want to talk to you. And the officer says, well, that's okay, Mike. We're going to take you down to hold you because we think you're involved in a crime. And then they start asking you questions. Now, Miranda warnings arguably are required because your freedom to terminate the encounter ended. But you might say, the police might say, well, we didn't put any handcuffs on him. Yes, but you did restrict his ability to end the encounter. So the courts do tend to look at the totality of the circumstances, not just whether a person has been handcuffed or not.
So, in your scenario where someone chooses to not answer questions throughout the entire process, Have you seen that be held against them later on in court?
So a person's silence is generally not held against them in criminal court. So there's a distinction: criminal court versus civil court. In civil court, you could theoretically have your silence used against you in proceedings, and a judge or jury may draw any inference, positive or negative, from you exercising your right to remain silent. But in a criminal court, it's a very different scenario. The Constitution is very clear. You have an absolute right to remain silent, and your silence cannot be used against you. And so it would be very hard pressed. And I don't recall ever seeing an instance in my 20 plus years where someone choosing not to answer a question uh, became an issue for them in terms of exercising their right to remain silent.
In a moment ago, you also mentioned about, well, they never read me my rights, right? So what happens if they read you the rights, but Miranda rights are violated? Does that automatically mean the case gets thrown out, or are there limits to what evidence is affected in that scenario?
So yes, and yes. The case is not automatically thrown out. However, the evidence that was obtained as a result of a violation of Miranda rights arguably is the fruit of the poisonous tree, which is from Wong v. Sun, which is a United States Supreme Court case. And basically, it says that if you obtained evidence based on a violation of Miranda, what evidence you obtained is spoiled evidence and it cannot be used in a case against you. Now, say it's a drug case and the evidence they obtained was, your admission that you were selling drugs, and they took the drugs off of you because they violated your Miranda warnings, and search and seizure, goes a little bit beyond this. But say the police violated your rights and the evidence gets suppressed or thrown out, and that's the only evidence they have, then yes, the case against you would be dismissed. Because otherwise the prosecutor would go forward with a trial and doesn't have the evidence. Well, they're not going to get it to a jury because the judge will say you don't have enough evidence. Now, in a more complicated case, it may be that there is certain physical evidence that was seized, but the Miranda warnings your Miranda rights were violated. But that doesn't mean that the physical evidence necessarily goes away. If there's an independent way that the police had obtained that evidence, then maybe your statements are no longer allowed to be used against you. But the physical evidence still may be, and there may be other independent witnesses who can testify about the situation. Now, there is an important exception. The judge agrees and says your rights were violated, Mr. Smith, and as a result, your statement cannot be used against you. Then you decide in your criminal case that you go to trial and you wish to exercise your right to testify in your own defense. Now, even though your statement has been suppressed, if you contradict the statement that you gave to the police, it comes in as a prior inconsistent statement, and you get around the Miranda violation, the government, because now you're saying something different. So, for instance, if the statement that was suppressed was the light was red, and then you take the stand and you say, well, on the stand, well, the light was green, then the prosecutor comes back and says, well, Mr. Smith, do you remember giving a statement to the police back on November 21st, 2025, and where you said that the light was red? Now, the lawyer for Mr. Smith's going to jump up and down and say, Judge, no, you suppressed that. And the judge is going to say, no, no, sir, I did suppress it. But your client chose to testify and he gave a prior inconsistent statement. And so that is why it is going to be admitted. I agree. If he had not said anything, that statement would not have come in, but your client chose to testify. So the important take-home message is, if your lawyer gets your statement suppressed, and then you decide to testify, you have to testify truthfully. And so a lot of times there's a real reason why you don't want to testify in a case, especially if your lawyer's done a very good job of getting evidence thrown out.
Adam, as we wrap on this episode, for someone that's listening to this right now, and they've already talked to law enforcement, but they didn't have an attorney present, immediately, what should they do right now?
You really need to be talking to an attorney, a criminal defense attorney, such as myself, uh, it may be that the damage has been done, but we may be able to mitigate it. We may be able to find technicalities that existed. Again, just because the police spoke to you and you gave a statement does not necessarily mean that that statement is admissible. There are many times when the police overstep their bounds and there's no one there to hold the police accountable. And so it's very important that you have your case examined by an expert such as myself.
Adam, thank you for the time and insights and sharing your story. We truly appreciate it.
Thank you. Have a great day.
And that wraps up today's episode of the first installment of Sidebar in the Sunshine State with Adam Pollack. If you want to learn more about Adam's work defending clients all across the state of Florida, do me a favor right now, visit orl-law.com. Thanks for listening, but don't forget, like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.